Welcome to this top-level guide to common aspects running through the collection of JCT contracts. My name is Lucy Garrett and I'm at Keating Chambers. I was called in 2001 and I specialise in construction disputes, including energy and shipbuilding work.
I'm Sarah Williams, I'm also at Keating Chambers. I was called to the bar in 2008 and I also specialise in construction, energy, onshore and some telecommunications.
In this discussion, we will look at two main features common to all of the JCT standard forms. Firstly, consideration of the effect of the JCT provisions in relation to pay less notices, the effect of the decision in ISG Construction and Seevic College, and some possible practical solutions to deal with the effect of that case. And secondly, consideration of the interpretation of the JCT conclusive evidence provisions in relation to the final certificate, together with the effect of the decision in University of Brighton and Dovehouse.
The purpose behind that, of course, is to say, well, all right, these interim certificates aren't conclusive, they're a provisional validity, and that was the phraseology used in the judgment. So bearing that in mind, you roll forward to 2003, where there was a Court of Appeal decision, Rupert, Morgan Building Services and Jervis. The question was, is summary judgment available to a party who's holding a certificate with no pay less notice against it? And the court concluded yes. However, the wording in the judgment is important. One quite important decision as well is one known as VHE and RBS Trust. That was a 2000 case at TCC level, in which case it was a serial adjudication. The first adjudication was brought by a contractor who, rather like in Rupert Morgan, had an application with no withholding notice against it. Well, the decision in ISG and Seevic is important. It's a design and build 2011 case. It's important because it raises a question mark over that point I was just discussing about the cause of action to get the right answer on an interim certificate. ISG Construction, the claimant, had put in its interim application. Seevic College hadn't put in a payment notice and it hadn't put in its pay less notice either, so you can sort of see where it's heading. And ultimately ISG sought a decision on the basis of the certificate. It got an adjudication decision for that sum, and Seevic College, thinking this is all horrible, brought a second adjudication, rather like in VHE. So the judge in the enforcement proceedings that then ensued had to decide what to make of all of this. And he decided that actually by failing to provide a payment notice or a pay less notice, the employer, Seevic College, had agreed effectively to the sum applied by the contractor.
What practical steps could parties put in place who are using the JCT suite to avoid the difficulties that Seevic faced in that case?
Well, the point raised in the Seevic case was, of course, they hadn't served any notices, so one practical solution would be make sure you know when your notices are to be served. The legal answer may be consideration of amending the JCT form prior to entering into it, obviously, to give you a right potentially not only for certification of a negative sum to unpick, 'cause we're living in the real world, sometimes notices are missed. So in the next certificate, in an interim suite of interim certificates, to give a negative sum to try and claw back some of the error in the previous certificate, say you're the employer.
Almost all of the major standard JCT forms of contract include provision for a final certificate, and they also include express terms as to what the effect of the final certificate will be, and it is what is known as a conclusive evidence clause. The commercial purpose of this type of clause, a conclusive evidence clause, has been considered by the courts on several occasions because they obviously feature in other forms of contract other than construction contracts. And the first is in a case called the Simon Burn, a shipping case, where Lord Denning said that they were intended to provide some limits to the uncertainties and expense of arbitration and litigation.
When do court and arbitral proceedings commence for the purposes of the clause?
In relation to arbitration, the position is governed by obviously the provisions of the contract, if there are any, and all the applicable arbitration rules. But in the absence of specific provision, it's governed by Section 14(3) of the Arbitration Act. The CDM regulations have been amended, so the JCT is, as one might expect, issuing updates to all of its standard forms to accommodate the new regulations, so that's a practical point for parties to be aware of. But the second, probably more interesting point, is that the latest JCT newsletter from April this year says that the JCT is intending to issue revised standard forms later on this year. So it's going to be very interesting to see what, if anything, the JCT does to reflect the decisions about the payment provisions and the final certificate and the various other clauses that have been considered by the courts over the last 3 or 4 years.